Hi friends, welcome back to this channel, Shruti Desai's lecture on law. We are learning mediation. We have made considerable progress in the subject, learning this subject, and I request all of you to continue to give me the same support what you are at present giving me, and your comments are most welcome. Do subscribe for this channel. We will learn every day something new. After mediation, we will also learn some new subject. We will decide on the subject next, but let us now concentrate on mediation. Last time I said that today we are going to learn what is impasse. Impasse is a situation where both the parties take a stand and they will never go in reverse gear, or they will not change their decision in the matter. So this is very this virtually fails the mediation process. Entire process of mediation fails because of impasse, and every prudent mediator must avoid this situation at any moment or at any point of time. May it be a personal private session, or it may be a caucus. Mediator has to be very vigilant to avoid this situation, and whenever such situation comes during the mediation process, then he has to change the subject. How he can change the subject? He has to say that, see, in that matter I did it, and see, they have lost it, and had they entered into such agreement, they would have been out of the court, and today they see how they are suffering, and they come every day and they spend a lot of money. Or mediator also can cite judgments. Here in Bombay High Court, the judges always say that don't fight, go for mediation, settle the matter whenever it is basically a family dispute. We have seen huge Kamani industries shutting down. In such cases, it's very serious matter when there is a dispute of this kind. We had also seen Reliance Industries, where there was a misunderstanding or a dispute between two brothers, which was rightly settled, and now both of them are flourishing and doing their own business, and also their relationship is intact. So we have to bring, as a mediator, this situation where parties settle their dispute and also maintain their peace, harmony and relationship, especially when there is a dispute within the family itself. At that time, it is a duty of the mediator to point out the consequences of litigation. That is must, and it is one of the finest quality of a mediator when he walks out of the impasse and again he dilutes the differences of opinion. Now, what is the origin of impasse? Origin of impasse is emotional. If it's a joint family separation or a family arrangement agreement on various properties and inheritance, at that time there is an emotional outburst, and there are so many issues where party can take a firm stand, and at that time it is very difficult for a mediator to take it reverse. So at that time he has to change the method, and also if he is in caucus, he has to go back to private session, and then thereafter he should talk both the parties, and then he should make organizational chart by which next step what is beneficial to both of them, that can be ascertained from the private session after caucus. Now another we see mostly in even matrimonial cases, for custody, for alimony, for residence, there is a stand always taken. So in such cases it's very difficult to go back, and therefore from the beginning mediator has to be vigilant. Now I have seen failure mostly in case of there's matrimonial disputes. In one of my matter, there was a matter which was referred to mediation, and mediator suggested something. However, I can say that the error was, instead of guiding, because see, mediator doesn't have much power. He is just a facilitator, and in India there is no supporting law by which he can take some legal steps. If you don't follow my instructions agreed upon in front of me, you are going to suffer this penalty or this consequences. Such provisions are not there. So in that case, it was agreed upon the mediator, and after 2 days, police came and picked up the wife in a petty matter. So in such cases, I feel that mediator must first ask the parties to approach the court, take the orders, what is decided in front of him, and then he should go for next session. So this also we see how the mediation fails. Vengeance is another reason of impasse. I'll show you, I'll teach you a lesson. So in such cases, mediation, during the process of mediation, there can be an impasse. Another reason of impasse is ego. Once I have taken a stand, I cannot change. This is a very difficult situation to change. Now, there are people who fear change. They feel that any change in their standard or thought process or a stand taken in the matter would affect them, or they might lose, or it is not in their favor. In such cases, there is an impasse. Now, what are the factors for failure or an impasse? There are 7 factors. See, can you read? Sorry. There are 7 factors which leads to failure of mediation. It's a frustration, aggressiveness, insecurity, loneliness, uncertainty, resentment, and emptiness. These are the 7 factors which is very dangerous, and it leads to an impasse. I have also seen in a mediation where some matters are referred where government or a corporation is involved. In such cases, suppose it is for recovery, suit is for recovery of revenue. Now, if it is a Mahada building, I'm giving you an example. This came across me, so I'm just giving an example. Let's suppose a Mahada or some another governing bodies who are the owners, and they have given on outright basis or a lease basis, or if it is a cess building, then corporation in Mumbai Municipal Corporation is collecting agent. But in a suit, if MADA is not a party, then they will not represent in mediation, because MADA is necessary party as they are the owners. But sometimes what happens that as a collecting agent, municipality issues the notice of for outstanding dues of revenue, and MADA therefore is not joined as a party. In such cases, mediation fails, because corporation will say that we cannot agree upon any reduction, because we are collecting agents and MADA is not representing in front of you before the mediator, and therefore we cannot agree upon any reduction or a waiver of any penalties or interest. So in such cases, mediation fails. So friends, now more on mediation next time. Till then, goodbye.